Hello, everyone. Welcome to the MSB podcast on Section 21. Is this the end? I'm Phillip Coburn. I'm a partner in the Social Housing and Regeneration team. I'm joined today by my colleague, Andy Moore.
Hi there. Yeah, I'm also a partner in the social housing team, specialising in antisocial behaviour, leasehold issues.
So both Andy and I act for landlords, and we're often instructed to advise on how to recover possession of properties. There's two normal ways to recover possession of property under the Housing Act 1988. One is Section 21 of the Housing Act, and one is Section 8. Perhaps, Andy, you could just give us an idea on the difference between the two.
Yeah, absolutely. So under the Section 8 notice, as everyone knows, is notice seeking possession, is effectively what the Act says is that the court cannot entertain any proceedings being brought until a notice is served under the section. In terms of what most people know when they're looking at Section 8 notices, is then the grounds that are contained within that. So there's a raft of grounds. I think it's 17 in total, although for the most part, we only deal with about 5 of them, I think, in most cases. But it's about 17 grounds for possession. Within that, there's A's as well, which deal with a raft of routes to say possession. Some of those are mandatory, some of those are non-mandatory routes of possession, which are dealing with things generally like rent arrears, domestic violence issues in the property, antisocial behaviour, breach of tenancy. So a raft of grounds there. And within Section 8 notices as well, there is specific time limits depending on which ground of possession you're looking to go for. In terms of Section 21 notices, they are known as, or they used to be known as, notices requiring possession, because effectively...
The wording's changed a few times.
Yeah, it has. So from a landlord's perspective, you are simply entitled to the property back because you can, effectively, it's your property. And so the general position, as I say, can change slightly depending on the length of the tenancy and the period of it. But the general position now is that if you serve a 2 months notice, you can then seek possession of the property back.
So it's a no-fault ground, really, isn't it? Whereas Section 8, we look at kind of a breach of tenancy or what fault there might have been. And I think sometimes landlords who are instructing us might want possession back, and there might be some breaches of tenancy, but sometimes it might be still appropriate to use Section 21, even though that indicates no fault, because there might be some problem doing it the other route, as Section 21 has that mandatory element, or almost if the paperwork's correct and there's no other arguments, then possession should be granted. So Section 21 notices are used for assured short-hold tenancies. For social landlords who use starter tenancies, they're a form of assured short-hold tenancies, so it can be used for those. And quite often the starter tenancies can be extended, can't they? I think it's usually a 12-month period, but sometimes as a lesser measure, landlords might decide to stick 6 months on top of that if the tenants breached the tenancy or appeared to have breached the tenancy.
That's right.
And with a private landlord situation, it's a case of getting the paperwork right. And if you get the paperwork right, possession is usually granted. But it can be a bit different for social landlords, can't it? And there can be some other arguments raised.
It can. I think from social landlords, I mean, generally it's going to start in the wording of your tenancy agreement, depending on what sort of starter tenancy you've got. It may dictate when you can serve your notices and the time limit to do so, especially, as you mentioned, with starters, then converted into full assured tenancies.
Yeah.
You need to be really careful.
Don't want to miss the date.
You don't want to miss the date on there. You need to be really careful about the conditions on that, because it might be that it's converted by the time you serve the Section 21 notice, and then you can't use it because you've only got the Section 8 available for it. Then you're looking at your policies and procedures as well, because most social landlords will have policies in relation to their starter tenancies and how they will end them as well.
Yeah.
And again, they need to ensure from a public law perspective, for charges on public law, that they've complied with their policies and procedures before they look to serve that notice. And it might be that there's appeal procedures in there, which for private landlords just simply don't exist, or it's it will be unusual to see in most private landlord cases.
It's just a discretion really, I think,
there
isn't
as
it?
well. And then as well, in terms of social landlords, as I said, I mentioned from a public law perspective, so you've got your reasonableness argument is would a public body serve a notice in these proceedings or in that particular case? So looking at it from that perspective, and then you've got the other aspects of it, which are rather unique to social landlords as well, which is the Equality Act arguments and the human rights arguments as well. Because in serving, generally, most social landlords won't serve a Section 21 notice and stop that tenancy converting unless there's a reason for it. Like you said, sometimes they'll use a Section 21 instead of using a Section 8 notice. But in terms of those reasons that they're looking to do that, let's say we've got somebody who's causing significant antisocial behaviour, but if that antisocial behaviour is linked to a mental health issue or a physical health issue or something like that, there may be equality arguments that are raised on there, because effectively it might be by serving that notice, that's discrimination effectively. And there needs to be a proportionate reason to do that. And then from a human rights perspective, on the face of it, you are interfering with someone's right to occupy their home and interfering with their family life by looking to see possession of the property as well. And they're the challenges that social landlords are open to, where private landlords might not be open to.
So although it's known as a no-fault ground, that the no-fault bit probably relates to more private landlords, whereas for social landlords, they wouldn't usually look to evict somebody for no fault at all, would they? There might be reasons behind why the Section 21 notice is used. So the no-fault ground for eviction kind of leads us to what changes are expected in the near future. So a few years ago, but prior to COVID anyway, there was a lot of pressure on the government to bring an end to no-fault evictions and change the types of tenancies that are given to tenants to give more security. So back prior to COVID, before everything changed, those proposed changes were to give more security, so perhaps end assured short-hold tenancies, but also bring an end to Section 21, bring an end to the no-fault ground. During COVID, obviously there was a so-called ban on evictions, wasn't there anyway? And everything was kind of put on hold. So those plans were shelved, and the bill that was proposed didn't really get off the ground. But the renters reform bill, as it currently is still waiting to be read in Parliament, and it's been delayed. But timing-wise, it's due to be read in May 2023 as things stand today. That could easily change again, as it has done several times. But I suspect that will become the Renters Reform Act. That will have quite a few changes, really. The proposed changes will be Section 21 goes. It will be no more, which is a massive change, really, because certainly it's been there for my entire legal career. Probably yours as well, I'm guessing. So it's quite a drastic change. Very good for tenants. Offers a lot more security. They will usually know if they've not breached their tenancy and there's no good reason, then they should have a bit more security. But I can see a situation where perhaps prior to any changes coming in, there might be a bit of a rush for landlords to get their Section 21s in at the last minute. And I imagine that might put a bit of pressure on local authorities in terms of their resources. So, any kind of thoughts on what pressure that might put on the councils?
I think you're right. I think you're right in terms of the rush, and particularly if you've got older tenancies as well, and the rental market changes. We know rental prices have gone up significantly, haven't they, over the last few years as well. So if you're looking at older tenancy and thinking, this might actually be my last chance to get rid of this tenant before to try and increase the rent in there significantly from what it used to be. But the knock-on effect of that is definitely going to be from local authorities in terms of planning. First of all, are there enough properties within the actual local area to accommodate people? And I think widely the position with that nationwide is no. And then we look at homelessness then. So if people are looking to present as homelessness, if the market there is not in private housing and in social housing, from homelessness perspective, then there are significant difficulties when it comes to homelessness and where to accommodate people. And there's wide reporting of families having to live in hotel/hostel accommodation for a significant period of time. It varies around the country. I know, there's particular issues in London with hotel and hostel accommodation there, but it's filtering up north. Most definitely, we're starting to see those issues that we didn't have up in the north in the past, and now becoming more regular as well. So, in terms of trying to accommodate people with local authorities, there's going to be those issues of trying to accommodate families out of the area. You can see out there as well, which could cause massive for people in terms of family life. So it may run contrary to what is trying to happen to try and shore up the security for families. There might be, before that comes in, a real period of upheaval for people.
Yeah, I could definitely see kind of an initial blow up or an adverse effect, which will be quite bad. What should happen? I think this change will happen. I think the Act will pass, and Section 21 will come to an end. But it probably will be a staged process. So initially, there will be a date when any new tenancy entered into cannot be an assured short-hold tenancy, or you cannot use Section 21 for those. But you'll have a runoff of older tenancies. You'll have people who've been living in properties for 20 years maybe, who are still on an assured short-hold tenancy and can still be subject to Section 21. So there'll likely be a second date, maybe 18 months later or 12 months later, when that abolition of Section 21 will apply to backdated tenancies as well. So they might give the local authorities a bit of relief, that there'll be some runoff, but I think at some point landlords will serve notices and maybe make a decision later, particularly where they're maybe looking towards retirement or a winding down plan of their assets. So in place of Section 21, the government have got to think about, balancing fairness between tenants and landlords, and the fairness to the tenant is more security in the end of Section 21. But you can have those situations where you might have a landlord who's not a professional landlord. Maybe they've inherited a property, maybe they've got one or two properties, which was a retirement nest egg, and they're coming to retirement and they want to look at getting that property back. And if the tenant's not breached the tenancy in any way and the landlord just wants the property back, there's going to need to be probably an expansion of Schedule 2 of the Housing Act in terms of grounds for possession. So when you mentioned before about Section 8 notices on which grounds to rely on, those grounds are going to have to be expanded. So, for example, if the property is genuinely on the market for sale, which is probably quite easy to put a property on the market and take it off the market, so there'll be those problems as well. So the government's going to have a proper think really about how that's going to work. The expected date, as I said, is May 2023 when it's going to be read, and there'll probably be a 6-month date from when the Act is passed to when this is going to come to an end. And as I said, thereafter there might be 12 months before old tenancies end as well. So really, just to summarise the position then, so over time since the Housing Act 1988 came in, landlords have been entitled to bring tenancies to an end through no fault, simply because there's been a fixed term and the fixed term's run out. And as long as the paperwork's correct, in theory, it brings to an end the tenancy and landlords can recover possession. That's easier to do for private landlords, although there's quite a lot of prescribed requirements to comply with. For social landlords, there's less prescribed requirements to comply with, but they're faced with public law challenges, which you'd gone through. And the legal position on that is proportionality. So a proportionate means of achieving a legitimate aim, the aim being possession, or to put it in another way, not using a sledgehammer to crack a nut.
Yeah.
Show your workings out about why you're looking to gain possession, and usually there is a reason behind that. The Renters Reform Act, as it will become, will bring Section 21 to an end, and in May this year, probably that will be read and it will be passed quite soon. And landlords will start needing to plan about what to do with their properties. And there'll be wholesale changes. There's changes already in Wales. These rules we're talking about relate to England, about different types of tenancies or contracts. So in Wales, they'll have occupation contracts, which are already in place. So we might be faced with something similar to that. And so really, it is a case of watch this space, because there's no chapter and verse yet. There's no draft or proper draft legislation really on how this is all going to look. And as usual, as soon as all this news comes out, MSB will be onto it straight away, and we'll be publishing our own thoughts about how this is going to work and how it's going to affect our clients. Any of this information will be available on our website. And the website also features a lot of other information on other areas of social housing, and also housing generally for private landlords. And that's really Section 21 in a nutshell. And the question is it the end? Yes, it's going to be the end very soon for Section 21.
Quite possibly. I think one of the ironic things as well is that there's been case law over the years when it's been enforced, and you've seen it, I've seen it, and we're probably at the most stable position with Section 21s at the moment in terms of the case law being settled, and now they might be going.
Yeah, everyone knows what they're doing, and it's all changed again.
Thanks very much.
Thanks, everyone.